Good morning. Today is the 12th of December 2022, and it's 10 o'clock in the morning. There's quite some snow outside in Vienna, if you are in Vienna at the moment. And this is the second episode of a series of 4 episodes dealing with issues that pop up in a European research project. Let me just very briefly share at the beginning with you once again what this is. The project is called TREIO, and it's about European investigation orders and training in European investigation orders. And in this series, we want to make you all familiar with the issues that are discussed and that are trained in this project. And it's my pleasure, my very, very big pleasure now to introduce the second expert to you today, apart from Katarina Polikonopoulos and Eva Korenjak, whom you know already because they are the two working in the Department of Innovation and Digitalization in law on the project at the moment. So apart from the two and myself, it's in particular Dr. Michael Schietz, whom I may introduce to you. Dr. Michael Schietz is working for the Austrian Public Prosecution Office in Vienna in the Department for Legal Assistance. So he is doing what we are talking about here on a daily basis. He came into this position after graduation of the University of Vienna. So I'm again very proud to say that Dr. Schietz is also an alumnus of the University of Vienna, where he finished his diploma and his PhD studies with a doctorate degree in 2005. Since then, he has been doing his legal clerkship and his legal education in a practical environment and has been working as a prosecutor at the PPO office, so the Public Prosecution Office, Vienna, since 2010. In the ministry, he is a member of the international unit, in particular in charge of MLAs and extradictions since 2012, and he has worked as the deputy head of the unit for 2 years. As you see from his CV, he is an expert in international matters of public prosecution and an expert, therefore, also in particular in the EIO. Dr. Schietz, thank you so much for being with us. Do you think that the EIO and its introduction has fixed a lot of the problems that existed with the old evidence system and the old evidence exchange procedure? And if it fixed a lot, what are the remaining issues that still remain within the system?
Good morning. I think the system worked quite well before, but the EIO made a formal process even more formal, and that tends to speed up things. As an executing authority, there are far less problems with double criminality procedures, double criminality check, or procedural questions. For example, we frequently had to ask for court orders as an executing authorities. That's not longer necessary. The double criminality check is not necessary in much cases. For example, if we only should conduct an interrogation, and that makes things much easier for us. A problem with the EIO is the form. I think most practitioners agree that the form is a mess. There are far too many subfields, and it's not logical that it starts with the measurements demanded and not with the facts of the case. So that's what I can say to that question, more or less.
Thank you.
So you mentioned that court orders are not, first of all, thank you for joining us, by the way, Dr. Schietz. You mentioned that court orders are no longer really necessary under the new regime. Can you explain why that is the case?
Because the law changed. Yeah, before the EIO, we always had to ask for the issuing authority to send us the court order, or if there was no necessity for a court order, to explain why there is no necessity. Now we trust the other state that everything is okay concerning their law. Otherwise, they wouldn't send us an EIO. So that's the reason for it.
Okay, so we just rely, under the new system, we essentially rely on the issuing authority to follow their own country's law. So, okay. Do you believe that there might be an additional risk in kind of skipping this step, or do you think that in the day-to-day, that as you see it, is it something that you think is an advantage?
I think it's an advantage because it's the European Union. We should trust the other member states, and you don't. If I ask another state for additional information, it takes weeks and weeks until I get an answer because you need translations, etc. So it speeds things up for really for some months or weeks at least.
Okay. And you also mentioned that the form is a bit of a mess. You said that it begins with the measurements demanded and not the effects of the case. Can you elaborate on that? What are the measurements demanded, and what do you mean by the effects of the case, and how would you kind of change it if you could have?
In the old system, the MLA requests usually started with the effects of the case, what happened. And then later on, the authority told us what we should do for them. So the measurements required. And I think that's the more logical thing to do. I think the form is also much too long. And the problem is you have section C, where are the measurements, and then you have section H with a lot of other special measurements. And it's sometimes people even don't use section H and put everything in section C. I think most people do now, and it's a problem because you tend to overlook then things which are in section H because it's not used very often. Yeah, I think you could just delete section H and it would work better. Yeah.
What is section H?
Special measurements for investigation. Like bank accounts or wiretapping.
Okay, so especially sensitive categories then of
more or less, yeah.
And have you noticed any market differences so far? So you spoke a little bit about them. Have you noticed any market differences between the old system and the EIO system?
Not really. As an executing authority, we had to create new forms, and it's even more formal. When we write orders to execute EIOs, we don't have to write much reasons anymore because we have to attach the EIO. So the EIO should speak for itself, and that's the main difference according to the Austrian law, I can state. But you have to use more forms like Annex B, and it's a bit more paperwork, I think, but it didn't change that much in the work on a daily basis, I would say.
Okay. And you haven't noticed any market differences between, say, processing time or anything like this between the old system and the new?
I don't think so. I don't think so. The
And
time limits are there, but like with the EAW, everybody tries to work as fast as possible, but yeah, they're more or less nice, but yeah, they don't have that great meaning, I think.
And have you used the electronic platform, so the e-codex system, extensively yet?
No, I haven't. We haven't received any requests until now. We are a pilot. We already have the system, but we haven't received any requests on the platform. I think the reason is there are not so many benefits using this platform, so people tend to use the old systems. I think it's more comfortable to write the EIO in a Word document and then create a PDF than use the reference application. So I think that's the reason why we didn't receive any EIOs via the new system until now.
Okay, so thank you also from my side for joining us. My question would be, if you go back to the process of issuing of the EIO, could you maybe just briefly describe the process for getting a request approved by a judge before it is sent to the executing authority? You
mean from the point of issuing authority?
Yeah, yes.
Yeah. In Austria, the EIOs are made by the prosecution office, so it doesn't have to be approved by a court. If I would need a court order in Austrian law, I also need it when I make an EIO. So, for example, if I want to have information about a bank account in Germany, I write the order, and then it has to be approved by the judge. And then after that is finished, I would make my EIO and then send it out. without the order and the court approval.
Okay, so quite simple.
Yeah, the only thing is most times you need translations. Yeah, so that's like always a big point. We in Austria, we don't accept machine translations like some countries would like to. Yeah, we're not big fans of it.
Okay. And has the direct contact between issuing and executing authorities, because this is a difference between the old and the new system, has this made a difference? Because in previous systems, as we know, there were like contacts between Ministry of Justice or between judicial authorities, and now we have the direct contact. So has this made a difference?
I think with most countries, we also had the direct contact before. The contact between the central authorities was just a theoretical thing, and with most countries, we had agreed that we could send the MLA requests directly. So that hasn't changed a lot. This would be one benefit of the reference implementation, because you could easily use the direct contact points there. There is a section for if you request further information or something like that. But usually you have email or telephone, so yeah, you can use that as well. I think that hasn't changed a lot.
Okay, so you would also say that the communication between these two authorities, so between issuing and executing authorities, remained the same, so it has not really increased or decreased?
No.
Okay.
One thing is before I refused to execute an EIO, I would have to ask the other member state, but usually we did that before, except when we were sure that it wouldn't work. So yeah.
Yeah, makes sense.
So in terms of the practical procedural differences between the old system and the new, the time limits, there are sort of more stringent time limits now, right? 30 days for response and 90 days for execution.
Yeah.
Have you noticed, have these deadlines have been respected by executing authorities? And
I can only talk about my office because I work mainly as an executing authority, and we try to respect them, but it's simply not always possible. When I had a case where the issuing authority wanted to hear, I think, 15 witnesses, and that's really difficult for the police to do that in time. Somebody's sick, somebody's on holiday, not in Austria, so 90 days sounds a lot, but isn't always the case. Or if we sometimes with some banks, it takes weeks and weeks and weeks until we get the documents from them. So yeah, we do our best, and I think we did before, so I don't think it changed a lot.
okay. It sounds like the new EIO system sort of codified what prosecutors' offices had been doing informally beforehand under the old system to a certain degree.
Perhaps, yeah. Perhaps you could say that, yeah. I don't know. We have a specialized unit at our office, and so EIOs are one of our main parts of work, and it's not something you do when you have time for it. Perhaps it's a bigger issue in other countries or at smaller offices where everybody has to do EIOs.
The new system reflects an increased concern for suspects' procedural rights. Article 14 requires the executing and issuing authorities to provide information about the possibilities under national law for seeking legal remedies. How do you accomplish this in practice?
There's a section in the form, and we, with an EIO, it's usually a remedy which has to be filed at the PPO and then is handed on to the court. So we write it in that section usually. It was often overlooked before, but then we got some requests from other issuing authorities. It didn't write about the possibilities for remedies, and now more and more it is done. And yeah, there are very rarely remedies in EIOs. It's much more common in extradictions, but in EIOs, it's really not happening that often.
And if I understand you correctly, this does not have to be communicated directly to the suspect, correct?
No.
Okay. So this is just something that the court needs to receive, or the
executing authority, but it's a court, mainly it's PPOs. So.
Okay. You mentioned already that the EIO regime contains numerous standardized forms and annexes. Have you noticed whether in practice they're generally correctly completed? I know you mentioned a little bit before that they're not always followed entirely properly. Or is it common that an executing or requesting authority is confused about which form to use or to correctly fill it out, how to correctly fill it out?
We use it for some time now, and I think more or less it works quite well. What I hear not only from Austrian but also from practitioners around Europe is that hardly anybody uses NXP. So that's one thing that doesn't really happen. I mentioned it before. Section H is often not used, which makes sense because it's sometimes overlooked because everybody writes what the measurements required in Section C. So I'm really not, that's one problem we have. The form is, in my opinion, too long, and there's no necessity for Section H because everything which is stated in Section H, you could also write in Section C. But yeah.
You also mentioned, so you talked about Section H, but could you also talk about Annex B, which you mentioned a few times? Because I think some of our listeners
Annex B is you tell the issuing authority that you received the EIO, and that's it. And it's we use it. We always issue a Section B form, but I heard from other offices that it's not used. Yeah.
Okay, so sometimes then the requesting authority doesn't actually have confirmation that.
Yeah, I think it's most times.
Okay.
Okay, and so maybe a bit different question. Do you think that EIO system may be also adopted in a different format based on some of the difficulties or specifics of the EIO system, and maybe even internationally? What is your opinion on that?
Yeah, as I said before, it's a lot of trust required with the EIO. So I think it would work with some states. I think the form which is prepared for the United Kingdom is quite similar to the EIO form. And I think it could work with some states, but I don't think internationally, at least not at the moment. Because the trust required is just really a big thing, and yeah.
Do you have a kind of value judgment about, because you mentioned the trust a couple of times, do you have any concerns regarding perhaps different respect for fundamental rights across different European countries? And so do you have an opinion about whether that's something that's risky, the level of trust?
I think not really with the EIO. It's more of a problem with extradictions. Like the conditions in prison are a big issue there, but not really in the EIO system. But yeah, with the conditions in prison, I think it's well known that there are problems with some member states. Yeah, and you always have to ask in which prison will the person be handed over and how are the conditions there, but not really with the EIO system.
And are standards kind of higher for extradition cases, or do you find that the EIO makes it easier?
I think extraditions are a complete different field. The the person concerned is far more involved because usually is in custody and mostly doesn't want to be extradited. With the EIO, the persons concerned are not that active in the procedure as they are in extradictions, which is logical because sometimes they don't even know about it. If we make a wiretapping or open bank accounts, the person concerned shouldn't know about it beforehand, but just in a later stage of the procedures.
Okay, so during this interview, I think it was mentioned a couple of times already that there are some maybe difficulties of the EIO form, so that is a bit messy, that is too long. Is there anything else that you would maybe change, or that do you have any maybe proposal how could it be improved?
I think at the beginning it was a big question in which states we would have to translate the EIO and which states not. Perhaps we could harmonize that because in that part the old treaties still are in force. But apart from that, I think the EIO system works quite well. Yeah. I don't have much proposals to do it better except from the form, but I think most practitioners agree here that it's not a big success.
Okay, thank you.
And the reference implementation, which has started now, is very basic. We had some proposal there, like automatically generate NXP. It wasn't possible. So I think for the practitioners to really use the reference implementation for the EIOs more, it has to give the practitioners some more benefits, because otherwise it's more comfortable to write it in a Word form and send it via mail or fax or postal service. Yeah.
Okay.
So the issue with the electronic form, you said, is the reference format?
We have a reference implementation which was invented by I think the company's Athos in co-working with the Austrian Bundesrechenzentrum. And I think it doesn't give the practitioners too many benefits, and that's why it's not used that much.
Perhaps I may come to close to an end with a very fundamental question, but still, I mean, this is a Department of Innovation and Digitalization working here, and therefore the question is whether you think that e-codex has a future in the sense of that it would be wider adopted than it is at the moment. You mentioned that many people don't use it yet because they don't see too much of an advantage. Do you think that there will be any change in this so that the advantages will either increase or will be better understood than they are at the moment?
I hope so. I think the main idea behind it was that we could directly get data from other member states without an executing authority in the other state. So if that would happen, it would probably be much more used than it is used now. And another thing is, I think many practitioners don't have many problems with safety of data. So I think if there would occur a problem, then afterwards the practitioners would more rely on safe ways like this.
Yeah. And what do you think that would be needed to support this development? Would it be education, or would it be technical implementation of certain measures so that people need to use it, or would it be a mixture of both approaches?
I think the first thing is at the moment not many authorities use it. So you would have to look up if the authority I would contact is already working with the system. And this is one thing which already deters some practitioners. So when everybody's connected, I think that would be a big step. Education is also perhaps a big thing, because when I spoke to practitioners from other countries in Austria, we use email a lot, and everybody tells us you can't use email, it's not safe, and there was no awareness in Austria until now, I think. So yeah, I think education is also a big thing, and
yeah. Okay, and email is probably better than many other things one might expect that might happen.
I'm not a technical, not a technical person, but many people told me it's not very safe. So I can only...
true. Yeah, people tend to say that it's like a postcard if it's not encrypted, right? What you're doing. Okay. Thank you so much, Dr. Schietz. Also, I'm very happy to hear that you think that training or education is important here, because as I mentioned before, this is exactly what this project is trying. It's about training in the electronic investigation order. If you want to have more information about the project, kindly look on the website. For the moment, I would like to close for today. Thank you so much for your time. I very much appreciate this in the name of all of us, in the name of the whole project, Dr. Schietz. I very much look forward to learning more from you about the practical implementation, also in particular of eCodex in the near future. Thank you to all our listeners and have a wonderful week. Take care. All the best. Bye-bye.
Thank you. Bye.
Thank you.